morning, everyone. Please be seated. And when you're ready, Madam Clerk. All right, we're here on the matter of Carollo versus Suarez. Please make all of your appearances.
Good morning, Your Honor. Jesus Suarez of Genovese, Jabal, and Batista. We are counsel to the plaintiff, Joe Carollo. In the courtroom with me today are my partners, John Aristilla, John Genovese, Richard Serkan, and our colleague, Joanna Zamora.
All right, welcome. And on the defense side?
Your Honor, good morning. Bob Martinez, along with my colleagues Frank Meadow and Lazaro Fields, and we're here on behalf of Mayor Suarez.
Good morning, Your Honor. Raquel Rodriguez from McDonald Hopkins. With me today from our firm are Mario Ruiz and Christine Demetriou. And we are here on behalf of the City of Miami and City Clerk Todd Hannon.
Good morning, Your Honor. Mario Rosenthal on behalf of Christina White, Supervisor of Elections in Miami-Dade County.
Good morning, Judge De La Haye. For Miamians for an Independent and Accountable Mayor's Initiative, we refer to our organization as Strong Miami, Ben Cuney, Marcos Jimenez, and Jennifer Bloom.
And I'll be pronouncing Miami if that's right, Mr.
It'll hurt me, Your Honor, but I understand.
And we're both in the same boat. All right. Then I think we're ready to proceed. Let me ask one initial question. Mr. Suarez had suggested in his papers, Mr. Suarez, on behalf of Mr. Carollo, had suggested in his papers that I not, were I to grant one of the motions to dismiss or any of them, not grant leave to amend, he was asking me to enter final judgment whichever way I go, correct?
As to the legal counts 1 and 4.
And as to count 2 and 3, you want me to take testimony?
As to count 2 and 3, I'd like to present evidence.
Got it. Do you have any objection to my treating the motions to dismiss that are currently pending by the defendants as motions for summary judgment?
I don't, Your Honor.
Okay. Do any of the defendants have any objection to my treating your motions as motions for summary judgment?
Your Honor, on behalf of Mayor Suarez, we do not.
Your Honor, ours was in the alternative for summary judgment, so we of course agree.
Okay.
Strong mind agrees as well.
Okay, excellent. Where are you all going to argue from? So, Mr. Suarez, if I could have you up at the podium, please. Let's begin with count 1.
Okay.
All right. So, as I read section 101.161, I think you and I can agree that the question is whether the ballot summary has described the chief purpose of the measure, right? It is not required that the ballot summary in detail, especially when there's a 75-word limit, provide the entire referendum for the voter, right?
That's correct.
Okay. And the standard I have to use is whether it is clearly and conclusively defective, right?
That standard is informed by other standards, Your Honor, which include the, it was all laid out just a couple weeks ago quite clearly by the Florida Supreme Court in the Greyhound racing case, which says that although the pole star of the analysis is the candor and accuracy with which the ballot language informs the voters of a proposed amendment's effects, the court has also recognized that the voters have the ability to draw logical and reasonable conclusions, but that an amendment may not be either affirmatively misleading or misleading by omission.
Okay. Do you have any obligation on behalf of Mr. Carollo to suggest an alternative ballot summary?
I don't. The Supreme Court, I believe it's also in the Greyhound case, has also ruled that the only available remedy is to strike the ballot language.
So this is a pass-fail test?
Pass-fail.
Okay, that's fair. So I'll let you go ahead and make whatever argument you want as to count 1.
Your Honor, I know you've read our paper, so I don't want to belabor the point, but what's very important about the Strong Mayor initiative is that it purports to transfer the powers of the city manager to the mayor. The logical inference is that this is a strong mayor just like we have in the county, and we're changing our form of government from a executive mayor commission form of government to a strong mayor commission form of government. But when you actually look at the text of the amendment and see the effect that it will have on the government of the city of Miami, it's so much more than just giving the city manager's job to the mayor. The amendment provides that the mayor is not required to be a full-time mayor, but may hire other people to do his job. The amendment also provides that there will be a change in the pay formula for the mayor's compensation, except that there is currently no pay formula in the mayor's compensation. It's affirmatively misleading because it leaves the voter with the impression that there's currently a pay formula and that you're changing it
How does the mayor currently get paid?
at the discretion of the commission, which is a vital check and balance that's built into the function of the government that disappears with this amendment. Also disappearing with this amendment is the commission's ability to have oversight over the management of the city, because they can't fire the mayor. Currently, they can fire the city manager. The city manager, in turn, cannot fire the city attorney and the city clerk. They're independent. So while the literal text of the ballot language says that the mayor will now have the ability to hire and fire the city attorney and the city clerk, it leaves the voter with the conclusion that those were things that the manager were able to do before, and now they're just powers that are being transferred to the mayor. When in reality, the entire scheme of government is changing in such a way that the commission's powers of oversight are being reduced by the change, and that is completely absent from the formulation in the ballot language. It is affirmatively misleading by omission. The reduced role of the commission appears nowhere on here. If this amendment were to pass tomorrow, or on November the 6th, the commission's powers to address administrative issues in the city through the oversight of the mayor would be, through oversight of the manager, would be completely destroyed by virtue of the fact that they can't oversee the mayor. And by virtue of the fact that the mayor is not only taking the city manager's job, but he's also taking a bundle of rights that belong to the city commission and subsuming them within his office. It's much different than the common strong mayor. When folks think of a strong mayor and they think of Mayor Jimenez, this isn't what they're getting here. They're getting something completely different. Now, I understand the argument that folks should have the right to determine their own destiny and need to have the opportunity to do so at the ballot. But
And also, how about the obligation that voters have to educate themselves? Don't they have such an obligation?
correct, but that obligation shouldn't be confused by misleading ballot language and a misleading proposal. And that's why we argue that counts 2 and 3 should inform the court's consideration, because this wasn't an amendment that was drafted in public. This isn't a CRC, a Constitutional Review Commission amendment that had the benefit of a public hearing and a give and take and public input and hearings. This was an amendment that was crafted in private by the committee and presented as an accomplished thing to the commission. Not to delve into the arguments on counts 2 and 3, because I know Your Honor would like for me to stay on count 1 right now, but it brings us to the important role that this court has of oversight to make sure that something that's inaccurate and misleading doesn't get on the ballot, because there was no public process. There was no input. This was a privately crafted and designed amendment that was brought to the commission. And when it was brought to the commission, the mayor specifically told the commissioners that they're putting it on the ballot to save $1.1 million in a special election. In other words, to schedule it right away would not prejudice the rights of anybody to challenge the fact that it was placed on the ballot, because you would have a recourse in court. And I can quote from the minutes of the meeting. The lack of affirmative disclosure about the effect of the amendment echoes beyond the ballot. when it says things like adopting a state recall procedure that already applies to the city of Miami, it's misleading. And the reason it shouldn't be on the ballot is because if it is in the ballot, and it's misleading on the ballot, then that's distorted in how the amendment is debated, how the amendment is presented by its sponsors to the public, and it hinders the ability of the public to inform themselves about the effects of the amendment. So now you've got a misrepresentation that made it onto the ballot language, and then every single day thereafter makes it into the voters' mailboxes. I get home to one of these every day. It talks about
Me too.
voters demand accountability. I mean, I read the charter amendment, and I think I had to read this thing 4 times before I could figure out that they were talking about our strong mayor initiative here, which is why it's so important that we get it right on the strong mayor ballot language on the ballot. This is the constitution of the city of Miami. It's going to outlast this mayor. It's going to outlast this commission. It's a set of rules under which the people of the city of Miami agree to conduct their business. And because it's misleading, because it doesn't inform anyone that the commission's role will be reduced and the oversight of the commission will be reduced, it doesn't tell people that the mayor will be a part-time mayor. It falsely states that we're changing a pay formula when there's no current pay formula. Those are reasons that the court can strike the amendment and enjoin the referendum. One more thing, and we've got a number of other enumerated points, but that I wanted to bring to the court's attention is the issue of the delegation of power. This amendment effectively delegates the right of the city commission to budget, takes away their budgeting rights to decide how much the mayor will be paid. And it completely delegates that right to the county commission. Not a single county commissioner is elected entirely within the city of Miami. So this amendment fails to tell people a very misleading fact, which is if you approve it, you no longer have the ability to tell your commissioners how much they should pay the mayor because they are stuck paying him at least 75% of what the county mayor makes, which is a figure that's set completely at the discretion of the Board of County Commissioners. That's a delegation of power to the county commission that is required to be affirmatively approved by the voters. Whenever state government, a city government, a municipal government sends power over to the county or back and forth, it has to be approved by referendum. And here, the referendum makes no mention of the fact that the right to set the salary for the city mayor is being delegated to County Hall. The issue that the mayor and the defendants raise and want the court to accept is that this is just about the mayor. Chief purpose, strong mayor, it's all in there. He's the strong mayor, and voters can say yes or no to strong mayor.
And voters can go read the amendment for themselves.
There's no reference to the amendment within the ballot language.
Is there supposed to be?
In the Matheson case, the third DCA, one of the reasons that they found it wasn't misleading is because there was a reference within the ballot language to the resolution that was being given effect, that was incorporating the charter amendment. That had to do with the park over in Key Biscayne with Crandon Park. And the proposed amendment had a whole number of things that would come into effect if it was passed. And somebody argued that it was misleading, and when the third DCA looked at it, one of the reasons they said, no, it's not misleading, it references the resolution. We get that there's a lot going on here, but a voter can inform themselves by going and getting the resolution. Here, we have confusion as to which resolution put this on the ballot, how it got on the ballot, and while the resolutions are the same, if we can't even agree here as to which resolution put this thing on the ballot, how are the voters supposed to figure it out? Which is why under the hiding the ball and flying under false colors test that was enumerated by the Supreme Court and asked you, the court can look at the entire thing, look at what it actually does to city government, see how it radically changes the balance of power between the commission and the mayor, a fact that is completely hidden from the ballot, and decide that the ballot language as presently stated hides that ball, because that was done by design to make it look like the strong mayor here, or the strong mayor in this case would become the same kind of strong mayor as he is in the county, would simply take the city manager's job, and it fails to tell the voters that they are putting many of the rights and powers of the commission into the hands of the mayor if this passes.
Okay, thank you, Mr. Suarez. Who would like to argue next? Mr. Martinez.
Your Honor, good morning. May it please support Bob Martinez. Your Honor, on this particular issue on count one, the court has articulated the questions that the court needs to consider, whether or not the ballot summary, 75 words or less, whether or not it describes accurately the chief purpose of the amendment, and whether or not it misleads. Those are the two standards. I think the most instructive case that the court could look to that was recently decided by the Supreme Court is the County of Volusia case versus Desner. That involves revision 5 of the CRC, which is Amendment 10 to the Constitution. And in there, the court addressed an amendment, proposed amendment that was in 4 parts. One established an anti-terrorism unit within FDLE in the Constitution. One established a Department of Veterans Affairs in the Constitution. Another one required, these are all part of the same amendment, another one required that the legislature meet in even number of years in January. But the one that was the big changer, the big game changer in that proposed amendment is the one that said that county government, those governments that have charter governments like Miami-Dade County, we can no longer decide for ourselves whether or not we want an elected constitutional officer or not. And it was mostly targeting the sheriff, because as we know in Miami-Dade County, we have an appointed sheriff, a director of public safety. That particular provision was part of Amendment 10, Provision 5. And the Supreme Court let that go to the voters. And that's probably the most drastic change in government that the voters are going to be considering on November 6th, Florida government. What that will do is that will take away our rights, everybody here, from determining for ourselves how we want to govern ourselves. Do we want to elect a sheriff and other constitutional officers or not? But it does much more than that in terms of its ramifications. If in fact that amendment passes, and we have to have an elected sheriff in Miami-Dade County, that will have a drastic effect on the budget of Miami-Dade County, on the division of assets, and might affect revenues and also tax raising abilities of the county in the future. And yet, the Florida Supreme Court let that go forward. That amendment was challenged on a number of grounds. One of them was the issue of the single subject of log rolling. We'll get to that later, probably as it relates to count 4. But with regards to whether or not it complied with Section 101, which is what count 1 is all about, what the Supreme Court said was that you don't have to set forth all of the changes, all of the ramifications of the effect of the change in the amendment. All you have to set forth is the chief purpose, and you don't have to set forth all the changes and all the ramifications. If you look at count of the complaint, the petitioner's complaint, in paragraphs 46 and 47, which is the heart of their complaint with regards to that count, what they allege is that the strong mayor amendment does not set forth all the changes, all the ramifications that will happen as a result of that amendment getting passed. And what the Supreme Court has said as recently as September 7th is you don't need to do that. You don't need to set forth all the changes, all the ramifications. You just need to describe the main effect, the chief purpose of the amendment, which this one does. But not only does it do so, but it also sets forth several examples. It goes beyond saying, well, it's going to be a strong mayor form of government as opposed to mayor commission. And then it sets forth how the strong mayor will, how those changes will impact local government. So it goes beyond what is required. It also sets forth some of the changes. There is no misleading, nothing misleading about it. As the court astutely pointed out in your questioning, the Florida Supreme Court in a number of cases, probably most effectively in the Florida Education Association case that we cite to the court dealing with the class size amendment, the Supreme Court said that the voters can use their common sense. We can rely on the voters having a certain understanding of government process. We can't assume that they don't know and that they won't do the homework. I think the court is right. I think the people, we should assume, they will apply their common sense. And when they see an amendment that is proposing a strong mayor form of government and also sets forth some of the ways in which they will do that, I think the voters can figure it out for itself. So I think that this proposed amendment more than passes constitutional muster as it pertains to whether or not it complies with Section 101 and the Supreme Court's guidance on that issue.
Thank you, Mr. President.
May it please the court, Your Honor. The only thing I have to add to Mr. Martinez's argument is to answer Your Honor's initial question about the standard of proof. And the standard of proof, as Your Honor pointed out, and is acknowledged in both the Askew case and the Greyhound Racing and Detzner case, is it has to be, you have to show by clear and convincing evidence either that it fails to describe the chief purpose or that it misleads the public. So the clear and convincing standard of proof applies to both prongs. Thank you, Your Honor.
Thank you, Mr. President. Mr. King.
Because Your Honor has had the benefit of substantial paper and excellent argument, strong Miamis simply wants to address three items raised by the plaintiff. First, it is of no moment whatsoever that the plaintiff claims this was an amendment done in secret. There's no law that says there's a different test. But what this amendment does is validate the right of the people to petition their form of government and to change their form of government after a number of unsuccessful charter amendment task forces were unable to bring any matter to the commission that was successfully approved. So the citizens took over that effort, and in a very public, not private, very public display, and we have that from the factual allegations, 20,000 legitimate voters approved the petition process and approved the petition enough so that the City of Miami Commission decided to put this on the ballot, directing the city attorney to come up with the appropriate language. So that argument is not only misleading, but it has no legal moment whatsoever in deciding this. The second is the nature of what's put before the voters in the ballot summary by the commission. The commission came up with the 75 words that are in the resolution, and although the plaintiff wants to require the details of the change of the form of government, the law as set forth in the pleadings and the legal papers says that's not what's required. Let's look at what the plaintiff argues. The form of government is different from what's said in the ballot language. Well, they don't argue that. They say the powers have not been sufficiently described. Well, the ballot language says this changes the form of government to a strong mayor commission form of government. That tells the voters this changes the form of government and the relationship between the parties. And then the nature of those changes are set forth. Duties, powers, and the voters can determine. Do we want to change from a manager, commission, mayor form of government? Remember, under the current form of government, the mayor is actually a commission member but holds some executive authority, but the executive authority is actually executed by the manager. Here, there's a strong mayor and a commission. Those are the policy makers. The amendment makes that clear. It does change the powers of those respective And the third item, which is, we think, a throwaway item, is the plaintiff continues to raise questions about how is the mayor's salary going to be set. This ballot language says there is going to be a process to set the mayor's salary. The commission remains the decider of the salary. All the formula change does is set a minimum, as though, in another context, the mayor has to be paid a minimum hourly wage. Would that be unconstitutional? Would that defer to the federal government or the state of Florida that sets minimum wages? Here it sets a formula, and the commission still decides, as it does today, what that salary is. We think that's a argument that is really intended to be more alarming than substantive, because it's simply one of many aspects of the charter change that 20,000 voters, petitioners, have asked to have put on the ballot, and the voters have a chance to say, do we want this form of government? We think under all the tests, this satisfies the primary purpose, change in the form of government, and provides enough specification that educated voters, and the documents reflect that there is extensive education about this, a website with the actual language, with lots of discussion about it. Voters in the city of Miami can be informed, they will be informed, and the court should presume that voters, in exercising their right to change their form of government, will be informed on a matter of this importance. We ask the court to find that count one is insufficient and a judgment should be entered in favor of the defendants.
Thank you, Mr. Chief. All right, Mr. Suarez, you want some rebuttal?
Brief rebuttal, Your Honor. The commission didn't draft the ballot language. It came from the committee. When the commission passed it out, they said, we'll take the committee's ballot language and let them challenge it in court. Somebody will challenge it in court. The issue of the 20,000 legitimate voters proposing this, and there being some sort of groundswell of support for this amendment, while not germane to the court's consideration of whether the ballot language is misleading, is also a misleading argument, because we have no way of knowing that 20,000 voters actually signed this thing. There was a process that everybody agreed applied, and that was 1223, until there was a challenge in court. And under that process, the circulators were supposed to be registered voters. And under that process, we have now identified, we confirmed yesterday from the clerk, that Ms. Rodriguez provided me the information that 11,294 signatures, about half, not more than half, of the signatures that were turned in were submitted by non-eligible voters. I'm sorry, by non-registered voters. And that's important.
Wait, you mean the circulator?
The circulator.
Right.
But the circulator is the person that turns it in. And there's a great fallacy in all of this. Everybody wants to set this case aside because, well, you're not saying that the people that signed it actually signed it, or didn't sign it. We don't know, because there's a process that's in place that everybody at the beginning of the process invoked, including the committee. And that process is, we have these people, we know who they are, they go around, they circulate the petition, they come back, they swear, they affirm, they sign every single petition, and turn it in.
And all of that still happens, and all of that still happened, except that you're saying some of the folks who did the swearing and the circulating weren't registered to vote. What's the connection between being registered to vote and making your observations and the papers you turn in any more or less legitimate?
The county, in its wisdom, passed County Ordinance 1223, and when it did so, it said that in order to prevent fraud and to have accuracy in the process, this was going to be a requirement for petitions that were circulated within Miami-Dade County. This petition was circulated within Miami-Dade County. And here, absentee ballots, and all sorts of other nefarious election conduct. And that was the deal. When the committee turned in their statement that said, this is how we're going to do it, they said, we're going to do it under 1223. That was a public representation to the world to every other voter in the city of Miami, to every commissioner, that this is the process that they were engaging in. They gave notice. They were required to give notice, and they gave notice. They said, this is the notice we're giving, this is what we're going to do, this is our plan to do it. I think the committee's lawyer at the commission hearing called it a blueprint when challenged on the applicability of 1223. Everybody thought that 1223 applied, and then they completely discarded 1223. And the reason that that's important is because under the First Amendment constitutional challenge, we will argue that bundling applies here under the First Amendment for the same reason that it ought to apply to the constitutional amendments, and that's that folks have the right to have their vote counted, respected, and heard. And under this process, the voters in the city of Miami were deprived of due process because they relied on the committee's initiative complying with 1223 to change or to bring this charter proposal before your honor. And then the committee didn't do it. And they didn't do it for many more reasons than just the registration of the electors. We'll get to that when your honor addresses those counts, the registration of the circulators. But it's this notion that there's a groundswell of support and that there should be deference given to the committee's proposal that I don't believe applies here.
But who's arguing for deference? I haven't heard that argument, nor do I think they get any deference. I look at the ballot language and it either passes the statutory requirements or it doesn't.
I think that's right.
Okay. But I'm not sure I've heard any defendant argue I should give them deference because they had 20,000 petitions.
Well, the notion that the court, in considering the serious request that is being made, that an election be enjoined, that a referendum be thrown off the ballot, and that it do so carefully and with the utmost reservation, I believe needs to be informed by the reality of the fact that the process failed to conform with any sense of due process to the voters of the city of Miami and to the commissioners that are having their offices that they were elected to, that they have a recognized property interest in, diminished. Back to the point of the word count and what they call my throwaway argument. My throwaway argument is very important because my throwaway argument is one of the few effective checks and balances that the commission has on the mayor. If you have a recalcitrant mayor, and in the city of Miami, I think we've been lucky to have many fine mayors, like the current mayor is a fine mayor and works hard for the people of the city of Miami. But what happens when we have the next mayor? What happens when there's another mayor? This is why this challenge is so important. When we have a mayor who perhaps doesn't act in good faith, and the commission needs to find some way to check that mayor's power. There's a very important check on that mayor's power, which is the ability to set the salary that's being completely abrogated, delegated to the county commission under this proposal, and it's silent. It's very craftily written in order to use the voters' common sense against them. Voters have a notion of what a strong mayor is, because we have one in the county. And that notion of what the county strong mayor is being used against the voter to mislead them with this ballot language. I understand that it's difficult to accurately describe this proposal in 75 words. But that is an issue completely of the committee's making. They didn't need to propose 48 different amendments to the charter all at one time. They didn't need to bundle in the mayor's pay, the delegation of authority to the county, hiring and firing the city clerk, in order to give effect to the change in the plan of government, how voters understand it, which is to go from a commission mayor plan of government to a strong mayor commission plan of government. Thank you.
Let's talk about, Oh, yes,
Sorry, may I take the podium? I need to clarify something.
absolutely. You use the least time of anyone.
Thank you.
I'll give you extra.
While we don't believe it's legally relevant, I do want to make sure that the record is correct. And perhaps it was a late hour and so much going on, but as counsel, I believe, misinterpreted the information that I gave him about the number of petition circulators who were registered voters or not. The email that I sent him said that the clerk had confirmed, had counted the number of petitions counted and circulated by petition circulators who were confirmed as registered electors of Miami-Dade County is 11,294. So I think council may have misrecalled or misinterpreted the email, but the 11,294 were confirmed registered electors. I just wanted to clarify that.
And were these individual petitions, or is it a petition that has a number of signatures?
This is the petition circulators.
Right.
Who, so those individual petitions, the 11,294, were tracked to individual petition circulators who were confirmed by the county supervisor of election to be registered electors.
So then what the city is saying, that we know for a fact 11,294 voters in the city of Miami signed a petition that was circulated by a circulator that was in fact under 1223 proper because they were registered voters. The circulator was a registered voter.
Right, to the extent that 1223 applies, which of course that's disputed in this case.
Well understood. Is that number final? That is, has a review been done of all of the circulators at this point?
A review has been done of all of the circulators by the city. I do not believe that the supervisor of elections has continued to review the ones that they were unable to confirm initially. So what the clerk's process has been in response to Commissioner Carollo's request was simply to tie each individual signed petition that was accepted to an individual circulator and then match that circulator to the Excel spreadsheet that was provided by the county supervisor saying whether the county supervisor had been able to confirm that the circulator was a registered elector or whether they had been unable to confirm. The supervisor has never said that that a particular circulator was not registered. They just stated they were unable to confirm at that time. And so that's where that stayed. That state of facts has remained static. Now this 11,294 number, it might change by 1 or 2. It's not going to be meaningful. This was a near final number that the clerk had yesterday. He was still confirming and cross-referencing, but it's not going to change meaningfully. It will not, make a difference to this argument.
Okay, thank you.
Thank you, Your Honor.
Anything you want to say about that, Mr. Suarez?
Ms. Rodriguez is right. Her email that she sent to me last night did say that there were 11,294 that were confirmed, so it's only the other 9,000, 10,000 that weren't.
That were not confirmed.
That were not
Okay,
confirmed.
got it. All right, let's move on to counts 2 and 3. Mr. Suarez. Their argument is pretty straightforward, and that is that I understand what you're telling me, that it was represented that Strong Miami was going to follow 1223, but the defendants are all pointing out 1223 does not apply, and the fact that they voluntarily chose to follow it should be of no moment now. Do you agree that 1223 doesn't apply by reading it, and I have to impose that obligation on them?
I believe you, Your Honor.
Why is that?
1223.
I'm saying aside from them voluntarily adopting it, am I required to impose it upon them even if they don't want to use it?
I think it does.
Okay.
The 1223 applies in elections throughout the county, the same way that the rules for the conduct of other elections in the county apply to elections that take place in the county. There's a county provision, the 75-foot rule, the little signs outside the polling places, all of those apply in elections within the county. This is a November 6th special election in the city that will be administered by the county, elections processed within the county. 1223 applies. 3 months ago, everybody agreed that 1223 applied until we realized that there was an issue with the committee not complying with 1223, and all of a sudden we started coming up with reasons why it shouldn't apply. And this goes back to the issue of notice and due process, and whether under a broader sense the court can enjoin this referendum because it lacked due process to the commissioners and to the voters in the city of Miami. There's no doubt that when this process began, there was an affidavit that had to be submitted to the city. That affidavit was accompanied by a cover letter. That affidavit put the world on notice that we were going to amend the city charter, and we were going to do so under 1223, because everybody thought it applied to the elections, to the circulation of petitions within the county, the same way that the 75-foot rule applies, or the requirement that ballots be translated into Creole, or a number of other requirements in the code. And that's all I have.
Well, but then they have their next argument, which is 1223 gets bypassed by the fact that the commission decided on their own to put this on the ballot.
That would be the issue that I tell Your Honor you can't decide on summary judgment, because our view is it didn't happen. That is just not an accurate recitation of the facts in our mind. I've got an exhibit that I'm prepared to introduce into evidence that says where the mayor gets up in no uncertain terms and says, if the commission does not place the measure on the ballot, our bosses, it's going to cost our resident, our bosses. So having received the memo that a sufficient number of petitions were certified, I called the special meeting for that purpose, and it's up to the commission to decide whether they want to put the ballot referendum, which was certified by the Division of Elections, on the November ballot or on some other ballot. And specifically reserved that Commissioner Carollo had every right to make whatever legal arguments he wants to make concerning the validity or lack of validity of the petition. So what I'm getting at, quote, is that you could put this on the ballot pursuant to the process, and it's still a challengeable process. In other words, someone can challenge and say, as the commissioner said, that section 1223 of the county court was not adhered to. So it's one more failure of due process to the voters of the city of Miami. We all said 1223 applied when we started this process. Every single petition referenced 1223. We bring this in front of the county commission in a giant hurry because we got to get it on the November ballot to save the voters $1.1 million. And what do we do now? But don't worry about it, everybody. This is fine because you can still challenge it in court. And now we come and we challenge it in court to say, as voters, we've been misled as the process that was going to be used to amend our petition, our charter. And now the response that we get from the same people who sponsored the initiative is, well, you can't challenge it in court. The commission put it on by itself. I think that is a lack of due process. I think that the plain text of the resolutions, which are incorporated in the actual body of the resolution, say, whereas it's pursuant to a committee initiative, we're going to stick it on the ballot. This would not be, as a factual matter, this would not be on the November ballot had it not been for the petitions.
Okay. Thank you, Your Honor. May I please support? I'd like to first address 1223. I think Your Honor hit the nail on the head. The initial issue is whether or not it simply applies of its own accord. It does not. I think the most compelling reason it does not is it does not claim to apply to municipal elections by its own language. In fact, quite the opposite. In 1223, section 2, it specifically references initiatives, referendums, and recalls submitted pursuant to Article 8 of the Miami-Dade County Charter. So not only does 1223 not purport to explicitly apply to municipal elections, it does the opposite. It invokes only county petition initiatives for referendum, recall, or ordinance initiatives. Also, I think very compelling was Your Honor, the minutes of the county commission meeting where they passed, where they amended this ordinance. They specifically did not give notice to municipalities, as they would have been required to do had the ordinance been purportedly applied to municipalities. So that didn't happen. Also, it is my understanding, and I let...
You're referring to the passage of 1223.
Yes, Your Honor, the passage of 1223. It's also my understanding that it's the county's official position that 1223 does not apply to municipalities. So I think 1223 of its own accord clearly doesn't apply. This issue of imposing a law that doesn't apply is simply a legal concept that doesn't exist. I think the closest legal concept they come to is a concept of estoppel, but the first DCA has made very clear there is no such thing as estoppel of law with respect to governments. Government employees cannot mistakenly claim that one law applies and then bind the courts and the citizens. The law that applies is obviously the law that applies, not the law that everyone thought applied. So I think very simply 1223 doesn't apply, and for that reason alone, counts 2 and 3 should be dismissed, or summary judgment should be granted in favor of the defendants. Secondly, the issue of the legislative act doctrine, I think, also moves all of these counts. Section 2112 of the Municipal Code of Miami gives 2 options for drafting of a proposed charter amendment. Option number 1 is there is a certification of 10% of the voters. Under that option, no action is required by the City Commission. The City Attorney drafts the proposed amendment of her own accord by virtue of the certification alone. There is no action by the City Commission. The second option, the alternative option, is the one where the Commission directs the City Attorney to draft the charter amendment. That is what occurred here. Once that happens, we are now traveling under the legislative act of the Commission. This is almost identical to what happened in Rainbow Lighting, which is the 3rd DCA case we cited in our briefs. In that case, there was a challenge to, I believe it was a fire commission tax or some sort of assessment by the city, and the challenge was to the underlying decree by the governor of Florida decreeing a financial emergency. And they said that the governor didn't have the authority to make that decree, and therefore the act by the commission is invalid. And what the 3rd DCA said, invoking implicitly the legislative act doctrine, is once the commissioners passed that resolution, the ordinance imposing the tax, we do not ask why. We do not care why. We simply say, was that a fairly debatable act that they did? It's the lowest standard of review. And if it is, which it is here, then that's that. And that makes sense, Your Honor. This has the virtue of satisfying all of our common sense. We can't relitigate things done, legislative acts done by legislatures and commissioners. And I think for that reason alone, Your Honor, in the alternative to 1223 not applying, counts 2 and 3, summary judgment should be issued in favor of the defendants. In terms of the evidence necessary, I think opposing counsel just put in the first resolution, which the existence of that resolution was the only fact potentially in dispute. I don't think that could actually be disputed. So if that's now in evidence, which we would accept and ask to be put into evidence, then that is all Your Honor needs to determine that this is a legislative act under the legislative act column of section 2112. And this clearly would satisfy the burden of fairly debatable, and that would also move counts 2 and 3.
Okay, thank you. Anything you wish to say, Mr. Attorney?
Your Honor, the only thing that I would add is to refer the court to section 6.03 of the county charter, which specifically provides the method by which municipalities may amend their charters. And by its plain language, it does not incorporate any condition on who may circulate a petition. And if Miami-Dade County wanted to change the way in which its municipalities could have their petitions amended or charters amended by petition, the only way that the counties could do so under the home rule that's incorporated in the Florida Constitution and under section 166.031 of Florida statutes is for Miami-Dade County to amend its own charter to address and to amend the charters of the municipalities within it. So an ordinance or a resolution would not be sufficient to change the way that municipalities in Miami-Dade County can pursue the petition process. It would have had to have been a charter amendment to the county charter.
Okay, thank you, Ms. Rodriguez. Mr. Chu?
Strong mind will address three particular items. First is the plaintiff's claim that all the municipalities in the county are governed by 1223. And as a matter of law, that's simply not correct. We've cited in the movement papers the Bal Harbour versus Mullen case involving a Bal Harbour charter amendment. The court never discussed 1223. The city of Miami Beach, the court can take judicial notice of the city of Miami Beach, which has implemented its own charter process. No application of 1223 whatsoever. And most importantly, as the city of Miami lawyer has explained with the county charter, the third DCA is made clear in the City of Miami versus Miami Association of Firefighters case. We've cited that case, 744 Southern 2nd 555. Quote, as the Home Rule Amendment makes the foregoing procedure exclusive, no limiting provisions may be engrafted on it. A county ordinance can't limit that section of the charter. This next item I want to address is this argument by estoppel. First, factually, the plaintiff continues to misread, charitably, the moving papers. We do not agree with the position that somehow Strong Miami can be obliged to bind the city of Miami and the city voters as to what it contended was the process. But having said that, Strong Miami never, and the documents reflect this, said 1223 applies. First, Exhibit D is the committee affidavit, Exhibit D to the complaint. And here's what the transmittal letter says. Pursuant to sections 1223 of the Miami-Dade County Code of Ordinances and sections 5 and 2-112 of the City of Miami Code of Ordinances, I am submitting the attached package as a citizen's charter petition. Then Exhibit E, also to the complaint, has the actual petition. The plaintiff contends the petition signed by the voters made clear, almost like it's in red lights, this is being done pursuant to 1223. If the court looks at the petition to amend City of Miami Charter, then it has the other languages. We, the undersigned qualified electors of the City of Miami, Florida, petition the City of Miami Commission to place a charter amendment on the next available ballot in accordance with section 2-112 of the City of Miami Code of Ordinances. In accordance with section 2-112 of the City of Miami Code of Ordinances. Then it explains and has a section for signature of the voter. That's the petition. The circulator section, which is the next page, not signed by the voter, not reviewed by the voter, not requiring any obligation of the voter, says, I certify to the truthfulness and correctness of the certificate set forth in 1223 of the code, county code. The circulator signs that, not the citizen, not the petition signer. And the certification is simply, if the court looks at 1223, certification that says the voter actually signed in my presence. There's no certification required for any other provision, and that's a circulator certification, not obliging the petition signers. And the third item to mention to the court is that the process used by the Strong Miami Committee brought forth 20,000 valid signatures of the voters. That's what the Home Rule Charter Amendment requires. To amend a municipal charter, a percentage of the voters need to submit petitions. There has been no challenge, none, nor can there be, given the supervisor of election certification, that 20,000 voters signed those petitions. That complied with the statute, that complied with the county code, that complied with the county charter, and that's what the Home Rule Amendment requires. Having done that, that's all that was required to validate these petitions. We believe that for those reasons, counts 2 and 3 should be ruled against the plaintiff and summary judgment or final judgment entered in favor of the defendants. Thank you.
Mr. Suarez, rebuttal.
.1223 says by its own plain terms, 1223-1, no person may circulate a petition or solicit signatures unless he or she is a registered elector in Miami-Dade County. No caveats, no qualifications, that's what it says. The committee adopted this process, and they gave notice to the entire world, to all of the voters of the citizens and the citizens of the city of Miami and the commissioners that they were going to proceed under section 12-23 of the Code of Ordinances. I want to address the legislative act doctrine. When this passed, and when the commission put this on the ballot, Mayor Suarez said, the concern I have is more practical in nature. If we don't put this on the November ballot, and this travels legally pursuant to some other time frame, then this is going to be on a special election and will cost the citizens of the city of Miami $1.1 million. So what I'm getting at is you could put this on the ballot pursuant to the process, and it's still a challengeable process. In other words, someone can challenge and say, as the commissioner said, that section 1223 of the county code was not adhered to. It doesn't say here that that has to be validated. And obviously there's some discussion as to whether that's constitutional or not, but those are all legal arguments. Whether or not someone, according to the commissioner, violated section 5A, it's a legal argument. And any elector of the city, I presume, can file suit and say that that was violated. So there are legal rights that are available to anyone who does not feel that this process was properly done.
But he can't create legal rights, right? But just by saying it.
Notice, process. The process was violated by the committee and by the mayor from day one. They made up their own process. They invoked 1223. They submitted petitions pursuant to an affidavit pursuant to 1223. Then they submitted 20,000 petitions, 10,000 of which approximately were collected in violation of that very same ordinance.
Let me give you this example. What if they said, we're only required to collect 20,000 signatures. We're going to collect 50. And they don't get 50,000 signatures. Can anyone come to court and say, but they told the voters they were going to collect 50,000 signatures. They only collected 40, more than 20, which is all the law requires. My point is, I agree with you that if 1223 applies, they have to follow it, right? But if it doesn't apply, it seems like your backup argument is they agreed to follow it. Therefore, Judge, you have to make them follow it. Why should I have to would I be able to force them to collect 50,000 signatures if they said they were going to?
They invoked the process. They told everybody this is how we're going to do it. Procedurally, we're not talking about substantively. They submitted 20,000 signatures. But procedurally, they said to people, this is what we're going to do. And in reliance of that, commissioners didn't propose other amendments. A commissioner could have put their own strong mayor proposal on the ballot, or rather the commission, that was submitted here under this process, that at a public meeting, they told the world, you can still challenge this process in court. So we're just scheduling an election. So now they come here and they say, well, the legislative act, you can't challenge it. At some point, the court has an obligation to protect the due process rights of the commissioners and of every citizen in the city of Miami.
You keep calling it due process, and I sit here and say, well, let the voters punish them. It's not my job to punish them and make up laws that they decided they were going to follow if they're not required to. If they're required to follow it, then I have a role. But if they choose not to follow, if they say they're going to follow a process that they don't have to, and then they don't, it seems like the voters are the ones that should be punishing them.
We've had no discovery. We haven't had the ability to create a record of any additional facts. We don't think the court can resolve the estoppel arguments, and it's not estoppel against the city, it's estoppel against the committee. The only thing the city attorney did was opine and say, you're right, if the committee invokes the 1223, they're bound to follow it. Now, the city has outside counsel and they're taking a different position, but for purposes of how this thing got on the ballot, that was what was in front of folks when it was presented that we were all going to follow 1223. And the notion that you can deceive the voters by saying, I'm going to create a process to bring you 20,000 signatures, and then I'm going to completely and totally not follow it, and still bring the amendment on the ballot, violates due process.
Where does it end when a politician deceives the voters? Anytime a politician says something that they go back on, you can come to court and try to enforce it if there's no underlying legal right to it.
Here there was an invitation to enforce it in court, to challenge it in court.
But you're sidestepping my question. Yes, I'm conceding we're at a summary judgment standard. Mr. Carollo, Mayor Suarez said those things, okay? But if there's no legal basis for him to say that these folks could come to court, am I supposed to now say, well, you said it, I'm now going to scour the record anytime a politician says something that may be deceitful, and I am not taking a position whether he deceived the voters or not. Please do not misunderstand me. But that's your argument. He deceived the voters and the commissioners about what they could do in court. But if he's wrong, how can I enforce it?
Well, he's not wrong.
But I understand that's the first argument, and then the rest of this is moot, if you're right.
He's not wrong, but it's the notion that the court has to protect the integrity of the ballot. Things have to get on the ballot the right way. The court is a gatekeeper of that ballot. And here, you've got, it's not a politician misrepresenting. This is a committee that misrepresented to the city what they were going to do, to the voters what they were going to do. And then a mayor who brought that committee's misrepresentation and invited the commission to put it on the ballot with the caveat that it could later be challenged. And we're here on that challenge. We'd like to take discovery as to the additional grounds on how this amendment failed to comply with notions of due process and integrity in the election process, but we haven't been permitted that opportunity. And at the end of the day, the argument that the committee and the mayor and now the city are adopting, or asking the court to adopt, is trust us, we did everything right, and if we said a whole bunch of things that weren't true along the way, oh well, too bad. And that's what that is. All along the way, they've been saying things that aren't true to get this thing on the ballot. And now they come to court and say, yeah, we were lying then, but believe us now. It's fine, don't worry about it. We did everything right. I don't think that should make it on the ballot.
So let me ask you this. I want you to make your record about what discovery you would have taken. My understanding from our initial conference, case management conference we had, is you wanted discovery on what representations were made by the circulators, that you wanted to have testimony about whether the circulators were eligible or not, eligible voters. When I read Buckley, I decided, even though I know Mr. Rosenthal does not want me to say that 1223 is unconstitutional, and I'm going to do everything I can not to say it, it seems pretty obvious to me it is. It just is. The Supreme Court's pretty crystal clear. So that's when I thought there's no need for discovery. However, I want you to make your record. What discovery would you like, and then I'll make a decision whether you're entitled to it or not, or whether it's going to make a difference.
Your Honor, we have requested discovery in order to show that this was a concerted effort to sidestep appropriate notice and due process to the voters and the commission between the mayor and the committee to kill a proposed city ordinance by the clerk that would have clarified these issues. B, invoke a process that they put out to the world, applied. C, completely failed to comply with that process in any respect. One of the things that's being lost here in the argument about the registration of the voters is the requirement under 1223 that petition circulators have a copy of the charter amendment with them. The petition circulators, by and large, did not have copies of any charter amendment with them when they circulated the petition. D, the petition language was misleading. Spanish is the primary language of a large part of the city of Miami, and the petition contains mistranslations that say that they're going to give the mayor the ability to hire and fire the prosecutor. Now, that wasn't a faulty translation on the petition because the proposed charter amendment that they submitted in Spanish uses the appropriate term, which is, well, I don't know that I could get Spanish into argument, but abogado, A-B-O-G-A-D-O. And that the entire process was designed in order to deceive the voters, in order to deny them an opportunity to understand and participate in what was actually going on. And then to tell the commission at the 11th hour that they had to put this on the ballot, but not to worry that it could still be challenged in court, only to come to court and say, no, you can't challenge it. Nobody had any right to participate or have their process respected, the rules to be followed in this process. The committee did whatever it wanted, submitted petitions that weren't circulated with the charter amendment, turned them all in, and then said, no, you got to put this on the ballot or it's going to cost you $1 million. It's not fair to the voters. It's not fair to the commissioners.
Let me ask the defendants, whoever wants to address it. I have to assume, for purposes of summary judgment here, that 1223 was violated in some way. I know you all are saying it doesn't apply, and I can make that decision on the law. But to make that decision, in order to grant summary judgment in favor of the defendants, I would have to assume 1223 was violated. Those are the allegations, and unless there's discovery, I can't make a finding on 1223, can I? Who wants to take it up? That it wasn't complied with.
Well, Your Honor, I think that what the complaint says, and that's all you should find, is, for purposes of the ruling, is that some of the petition circulators were not registered electors. That's what the petition alleges. And also that there wasn't a complete, I don't recall exactly where the complaint says this, so.
But it also says that there was a mistranslation of municipal attorney versus city attorney.
That's correct.
I mean, municipal prosecutor versus city attorney.
Yes, but the point I wanted to make and I think the board can credit those, but the point I wanted to make also is that the board should look at what's undisputed and makes that argument or those facts irrelevant, which is Mr. Cuny cited the fact that the exhibits to the complaint don't really mention 1223, but more importantly, the city yesterday filed, I think it's in the record, the resolution
was in fact violated?
Correct.
But if you lose on all of those arguments, then I have to find 1223 was violated, or I need to open this case up for discovery as to whether it was violated. Fair?
I think if the court decides that legislative action does not apply,
That the county ordinance applies.
before it applies 1223, or decides it wants to apply 1223, then it would have to decide whether or not it's constitutional.
Correct. Well, only the circulator part. I don't know that Buckley really addressed anything else.
Yes, as to the circulator, correct.
Okay. So I think the answer to my question is yes. I can assume it was violated, assuming you lose every other argument, I
Yes.
get that. All right, and are the defendants willing to stipulate that the portions of Mr. Suarez has quoted of Mayor Suarez's statements are accurate? That was in fact said. So I don't need discovery of that.
Yes.
Okay, great, thank you. Okay, so I think we have finished with counts 2 and 3. Let's talk about log rolling, or bundling as Mr. Suarez referred to it. Whenever you're ready, Mr. Suarez.
Your Honor, this is an argument that's currently pending before the Supreme Court in the Anstey v. Dietzner case that was filed by Professor Joe Little in the, as an original petition for writ of quo warranto. And the argument that former Justice Anstey has advanced in that proceeding is that by bundling amendments separate and apart from the single subject requirement that we understand does not apply to constitutional review, commission amendments, and does not apply to municipal charters.
Okay, that's where I wanted to
Yes.
start, because after reading City of Miami versus Miami Association of Firefighters, there is no argument.
I'm not arguing that,
Okay.
that the single subject requirement applies.
Okay, so
This
it's a
is-
constitutional change.
This is an argument under the First Amendment of the United States Constitution that by bundling all of the amendments together and forcing voters to pick between something they might want, giving the mayor the responsibilities of the city manager, and something that they don't want, removing commission oversight and addressing mayoral pay issues. I don't think there are many voters that are excited to pay the mayor hundreds of thousands of dollars a year. That violates a voter's right under the First Amendment of the Constitution. I think we'll get clarity from the Florida Supreme Court on this issue at some point along the road. It's been fully briefed before the court for some time now. And the argument advanced is that by forcing people to take something that they want with something that they don't want, you're violating their right to speak as to what they do want if you're conditioning it on what they don't want. There isn't any precedent that is binding on this court on that argument, but we're obviously here to encourage the court to apply the rights that all voters have under the United States Constitution to the facts that are at issue here. So it's not a single subject argument, it's a constitutional First Amendment argument.
Mr. Martinez.
Your Honor, may I please the court, Bob Martinez. With regards to count 4, Your Honor, there is no authority. There's no authority at all. It says that the First Amendment, great amendment of the United States Constitution.
We're all fans.
It's a big amendment, we all like it. Provides the constitutional right that the plaintiff is seeking in this particular case. With regards to the issue of log rolling, I think the court can look to the case that I mentioned to the court before, which is the County of Volusia case versus Desner, dealing with, I believe it was Revision 5, which is Amendment 10, CRC Revision 5, Amendment 10 to the Constitution. And in that particular case, the Florida Supreme Court unanimously allowed Amendment 10 to go to the voters, and that amendment puts together groups, bundles, aggregates, whatever word one likes, 4 very different topics, 4 amendments dealing with 4 very different Givers ruled on. By the way, she said that her rationale as it applied to revisions 2, 4, and 6 also applied to revisions 1, 3, and 5. And revision 5 was the Amendment 10, the one I just mentioned. She said that her rationale also applies to those, and yet the Florida Supreme Court has held that with regards to the ones that it approved to go to the ballot, 2 out of the 3 that it looked at, that revision 5, Amendment 10, that could go to the voters. So that wasn't stopping going to the voters based upon any constitutional argument. I don't think, I'll be honest with the court, I don't think that Mr. Rosenthal, who was part of that argument, can tell us. I'm not aware whether or not the First Amendment was actually teed up with regards to Amendment 10. Someone will let the court know that I want to be straightforward with the court. But nonetheless, the Florida Supreme Court did let go to the voters Amendment 10, which grouped together 4 very different topics.
Okay, thank you. And you want to weigh in, Ms. Rodriguez?
No, Your Honor, I think Mr. Martinez covered everything. Thank you.
You want to say something, Mr. Rosenthal?
No, just to the reference, I did argue the Amendment 10 case on behalf of the county. The county did not make that argument. The Lucid County did make that argument in the case, and the result was as Mr. Martinez says.
Okay, thank you. Mr. Kennedy?
The committee rises to just address a fallacy in the plaintiff's First Amendment argument. The argument, if it has any validity whatsoever, and we don't believe it does, is based on the presumption that there are separate topics that are not germane, and that's what their First Amendment argument is, separate topics. This is not, as one of the approved constitutional amendments is, the topics of vaping and oil drilling. This is all changing the form of government. That is the topic. And every aspect of the Charter Amendment deals with changing the form of government. There is, for example, no charter change that says we require bicycle lanes, or we're going to make sure that we have more parks in the city of Miami. This is all about the structure of the form of government. That's a single topic. It may have a lot of moving parts, but government, a form of government, has a lot of moving parts. So even if there was some essence to the First Amendment argument, it fails as a matter of definition because the form of government, the ballot summary, and the actual amendment is one topic, changing the form of government.
Thank you. Mr. Suarez, anything else you wish to say on count 4?
We're not arguing single subject, which I think is the argument that I heard from the committee. We're arguing bundling, taking the good with the bad, putting in the issue of the mayor's compensation, which has nothing to do with changing the form of the structure of government, in the sense that we don't need to pay the mayor more in order to make him a strong mayor. But that's what they want to put in there because they know that it's going to put the things that are unpopular with the good ones. If they put a standalone provision saying we're going to pay the mayor 75% of the compensation of the county mayor, which I believe is budgeted at $400,000 and something a year, that would never pass. So they've taken the good, allegedly, lumped it in with the bad, I agree, and are asking the voters to do that. When they do that, they violate folks' First Amendment rights to say yes to this, no to that. And Mr. Martinez is correct that the Deepsner case he cites did not address the First Amendment grounds on First Amendment grounds.
Okay. Anything you wish to say about count 5? The writ of mandamus?
We're asking for that relief, and it would apply if the court found that the 1223 was the appropriate procedure.
Otherwise it would be moved.
Otherwise it would be moved.
Does anyone else wish to address count 5? You've addressed it plenty in your papers.
Your Honor, since count 5 is mostly directed to the clerk of the city, I guess I ought to say a couple of things about it. There's no point in a writ of mandamus, as was discussed earlier. The city clerk has now gone back and tied the petitions to the individual circulators and provided that data to Commissioner Carollo, and now that number is in front of the court. And so to require the clerk to go back and redo the same thing, it's pointless. And and it also would be futile because the city commission separately adopted the ballot referendum language and passed it independently of a petition. So if Your Honor agrees that the commission had the power itself to put the item on the ballot, then there is no need to grant the writ of mandamus because it would be futile. The mandamus does not apply to compel a futile act. Thank you, Your Honor.
Okay. Anything else anyone wishes to say, Mr. Suarez?
Just one more thing for the record, Your Honor. To the extent that the court is inclined to consider the constitutionality of the 1223 of the county ordinances, procedurally, we don't think it's before Your Honor. The defendants are compelled under state statute and Florida Rules of Civil Procedure to bring in the county and give notice to the Attorney General or the state attorney. I don't believe that has been done here. So if the court were to reach the constitutionality of 1223, our position is that it's premature.
All right, folks, I will do my best to be done by today. I think it's more likely sometime during the weekend. I will get you in order, but you'll certainly have it by the time the court's open on Tuesday morning, and you can, whichever side wants to proceed, can proceed accordingly. All right, anything else?
Thank you.
All right, thank you all.
Thank you.
All right.